Good morning. I'm Dr. Neeraj Nagpal. I'm convener Medicos Legal Action Group. Number of times this question has been asked to me that what should be done and how a reply should be made to a letter or a complaint or a threat in writing made by a patient or his relatives of patient who has been treated by the doctor. The complaint may have been made to the hospital where the doctor may have been working, or the complaint may have been made to the doctor. The process to be followed is remains the same. The first and the foremost thing which has to be done immediately on receipt of any such complaint is that you have to intimate the indemnity insurers in writing via email as well as via registered post, and preferably if a by hand letter can be delivered or with receipt, that is the best. They have to be intimated that we have received such and such letter or a complaint, and this complaint or a letter may give rise to a claim later on. This has to be mentioned very specifically in the letter. Why this is important is because all indemnity insurers in India today are not giving event based policies, but they are giving claim based policies. And if during the policy term you do not intimate them that there has been an event which may result in a claim being filed later, because the claim may be filed many years later, and then if the insurers are not insuring you there at that time, they will refuse to bear any liability regarding from this compensation which may be awarded. So after intimating the insurers, the second step you need to do is retrieve all the records which you have of this patient. Study them thoroughly. Make sure the records are in order. Ideally, I would request not to make any alterations in the records, because uh, patients today are clever, and sometimes you will find that they have already made copies, or they have photographs, or they have photostats of your medical records. So preferably the medical records should be studied, they should be understood, and after that only any kind of reply should be made to the complainant. Third point is, yes, a reply has to be given when you receive a written complaint or a notice from the patient. Again, I am specifying this is not from the advocate or from the consumer court. So when you formulate the reply, you have to reassure the patient that you are taking the feedback or the complaint very, very seriously. You are going to conduct a thorough investigation, and you are going to improve the system based on that investigation, and including any penalty which has to be imposed on the culprits, if any. The patient should not get a feeling that the complaint which he has made has been consigned to the dustbin or there has been a cover up. The investigation which is being promised should mention that there will be outside agencies which will be involved, so that the patient is reassured. Assume also, the fifth point is that you assume also that the patient has asked for his medical records. Why do I say this? Under the Indian Medical Council Act 2002 regulations, it is very clearly specified that when a patient or an authorized representative asks in writing for the medical records, they have to be provided within 72 hours. We have number of High Court judgments, latest from Allahabad High Court, which has upheld this, and not providing these records per se has been construed to be negligence. Now, if on receiving a complaint, even when the patient has not asked for the medical records, along with your reply, if you do give them the medical records, it satisfies the patient that there is complete transparency. And you don't lose anything, because anyway, if he had asked for the records, you would have had to provide. And if the person is making a complaint, there is a good chance that he is contemplating taking action, and asking for records will be the next step. So if you preempt that, there is a good chance that you will satisfy the complainant or the patient that you are serious, you are transparent, and you are not hiding anything without actually losing anything. Keeping these things in mind, after you formulate, then you formulate your reply. But the reply should be bland. The reply should include a categoric denial of any negligence. The reply should state very clearly that you have followed all medical protocols to the best of your ability and there has been no negligence. Whatever defenses, legal defenses you have, there will be number of errors or misconceptions the patient has had, and in the complaint there will be many errors. But if you try to rectify those errors by giving them the defenses which you intend to make in court, you only succeed in allowing the complainant to improve the complaint when he goes to court. So do not disclose your defenses which you are going to use in court, but definitely make a reply. The reply should be bland, be proactive, provide the patient all the medical records. So when he gets a copy of 40, 50, 60, 100 pages, he is he gets satisfied that his complaint has been taken seriously. The hospital is being transparent, they are not trying to hide anything, and you have not divulged anything which will be detrimental to you when you fight your case in court. So I think these are the steps which are most important when you receive a complaint or a notice from a patient party or the relatives. We will discuss a notice, what to do when you receive a notice from an advocate, what to do when you receive a notice from the consumer court, all these separately. But today we will end with this. Thank you so very much.